Elective course Ethics and Medical Jurisprudence, second BHMS, professional course CBDC. Module 4 Indian Medical Jurisprudence. This is lecture 3 now regarding documentation and medical records in homeopathy. Speaker is Dr. Ragini Raut, MD Home, HOD, Associate Professor, Department of Forensic Medicine and Toxicology, Bharati Vidyapeeth, Homeopathic Medical College, Pune. This lecture 3 has documentation and medical records in homeopathy. Importance of accurate medical documentation, legal requirements and standards of medical records, confidentiality and data protection laws, case studies on documentation issues. All these topics will be covered by this module under the documentation and medical records in homeopathy. Accurate medical documentation is required in homeopathy for continuity of care which ensures consistent treatment and follow up. In this, the first part is communicate treatment prognosis to the patient, which ensures good communication. Legal protection protects the practitioner in case of legal disputes or malpractice claims. Right documentation throughout the treatment with communication to the patient and their relatives. This will help the doctor for self defense if some situation may arrive in the future. Accurate medical documentation requires in research and analysis also. This facilitates research analysis, improvement of homeopathic treatments. Research improves the quality care and skill of doctor. This improves the patient safety also, which helps to identify potential allergies, interactions and adverse reactions. For this, right information after taking the history, which helps to know the various allergic conditions of the patient by asking them history, past history or his family members history, so that you can be, so the patient's safety can be ensured from our side. Accurate medical documentation is required for the homeopathy for the quality assurance, demonstrate adherence to the standards and guidelines. Patient's empowerment, which informs the patients about their treatment and health status. Present status and what is the present treatment the patient is taking and what is the present health status and what is the requirement of the sufficient care to be taken by the physician has to be explained to the patient in detail. Communication. This enables clear communication among the healthcare professionals. Proper and pure communication is required. Communication is main breaching the doctor-patient relationship and it will develop to have a proper rapport with the patient. Audit and evaluation. Whatever the facilitates evaluation of the practitioner performance and clinic quality. Teaching and training. It serves as a resource of teaching and training homeopathic practitioners. Training helps the doctors get updated on various recent diseases, treatment, their prognosis which helps to treat and patient in the new disease cases. Also by training and teaching, we can update our diagnosis, our treatment protocol and we can assure or we can guide the patient about the timeline about his treatment. So, it will help the patient and the doctor both the ways. Regulatory compliance meets requirements of regulatory bodies and laws. Accurate medical documentation in homeopathy ensures compliance with regulatory bodies and laws, meeting the essential requirements for legal standards, patient safety and quality assurance in the practice. So, this helps in forming the regulatory help in the regulatory bodies also and laws also, so that patient safety can be assured. Accurate medical documentation also helps the patient personal and medical history, and whatever the patient personal history and medical history data you are collecting absolute confidentiality and patient secrecy has to be maintained on the part of the doctor. Symptoms and diagnosis, whatever the symptoms you are accumulating, proper diagnosis should be assured. By taking the symptoms and by giving the diagnosis, you can plan the treatments accordingly, and by planning the treatment, your prescriptions should be accurate in the same way, which will help also to keep the follow-ups also properly, and by keeping the follow-ups, you can go for the progress of the notes, that is called as the prognosis, where we are, in which direction we are going, and that direction is really helpful and positive for the patient or not, that we can decide by keeping the follow-up with the patients. Then test results and investigation, as we have discussed, there are necessary investigations which help you for the proper diagnosis, and for the proper diagnosis which will help you for the treatment part. So, test results and investigations are required. If the patient is allergic to something or he is sensitive to certain drugs or medications or certain items, so we should, by taking the history, we can assure about the allergies and sensitivities of the patients. Then medication list, whatever the medication patient is taking, you should know he is going under which medication. Then correspondence and reference, whenever there is a requirement of taking the opinion, so you should be corresponding and you should refer the patient whenever it is near, if it is a case of emergency or casualty affair, so you should refer the patient to the biggest institutes. Informed consent and patient agreements, whenever you are dealing with the patients, critical cases, emergency cases, you should always take the informed consent and patient's agreement for the same. Practitioner notes and observations, whenever you are dealing, what is the prognosis, what are the investigations, what is the patient status of the patient, or if you are referring the patient to the other physician. So, practitioner's notes or opinion, or after seeing the patient, after examining the patients, what are your observations, your findings are required to write down, which will help you for the say in the future if something went wrong. By maintaining the accurate and detailed medical records, homeopathic practitioners can provide high quality care, reduce the risks and enhance their professional reputation. By doing all these things, we can give the quality care to the patients. By giving quality care, right diagnosis, we can reduce the risk and you can assure about the patient safety, and by doing that, you are maintaining your professional reputation in the society. Legal requirements for medical records in homeopathy. Indian Medical Council Act 1970, the Indian Medicine Central Council Act 1970 mandates the maintenance of the medical records in homeopathy. This ensures compliance with the legal standards, facilitates continuity of the care, supports effective treatment, planning and upholds transparency and accountability in the medical practice. Accurate documentation is a crucial for meeting the regulatory requirements, enhancing the patient's safety, that is mentioned under the Indian Medical Council Act. Homeopathic Central Council Act 1973 specifies requirements of medical records. The Homeopathic Central Council Act 1973 specifies detailed requirements of medical records in homeopathy. It mandates accurate documentation of the patients, information, treatment plans, progress, ensuring the compliance with legal standards and promoting transparency, that is, you should keep the professional secret, and whatever you are giving to the patient, you should have a clear cut idea to yourself and to your patients also and the patient relatives also, which will promote the transparency, which will help to continuity of the care and which will help the accountability and responsibility of the homeopathic practitioner. Now, this act of CCH is been named as a National Collection of Homeopathy Act 2020, and certain things have been replaced by the previous acts. There is a Consumer Protection Act 1986, which requires maintenance of records to establish standard of care. The Consumer Protection Act 1986 mandates that homeopathic practitioner maintain comprehensive medical records to establish a standard care. This is mandated to all the homeopathic practitioners who are practicing over here. This legal requirement ensures the patient's treatment is documented accurately, supporting transparency and accountability. Proper record keeping helps resolve the disputes, demonstrates adherence to the professional standards and safeguards the patient's right in legal consents. Indian Penal Code 1860 section 294 makes it an offence to destroy or alter the medical records. Under section 294 of the Indian Penal Code 1860, it is a criminal offence to destroy or alter the medical records in homeopathy. This provision ensures the integrity and accuracy of the patient documentation, safeguarding against the fraudulent practices and ensuring the records which remain available for legal scrutiny, continuity of the care and regulatory compliance. So, any fraudulent practices happens or if the patient came are relieved or getting satisfied treatment and he came after some years, this record will help you to scrutinize if any legal issues happens. So, it will help and guide and work as a safeguard as a to the doctor. How many days or how many times he is continuing his care, that can be analysis by this, and this regulatory compliance can be given in cases of the offence or in cases of the laws. Clinical Establishment Registration and Regulation Act 2010 specifies standards for medical records. So, in what kind of standards the medical record should be maintained? The Clinical Establishment Registration Act and Regulation Act 2010 sets standards for maintaining medical records in homeopathy. It mandates comprehensive documentation of patients' histories, past history, family history, drug history, whatever he is taking, any operative procedures, his family history, everything is mandatory to have a documentation. Treatment part, what he is taking treatment from you or what are the treatments he has taken previously, what are the treatment he is taking for the other illnesses and what was the outcome of that treatment, record should be maintained. Ensuring the consistency and quality in the care, then compliance with these standards is crucial for the legal registration and regulatory oversight and providing transparent and accountable healthcare services. Under the Clinical Establishment Act, specific standard medical record has to be kept properly and it is mandated to all the doctors. Legibility, record should be legible and easy to read. So, no special techniques and handwriting should be done. So, it should be legible, it should be readable for the authorities. The medical records in homeopathy must be legible and easy to read, ensuring you should not write down the record or keep the record in the secret formulas. So, ensure that all the documentations are clear and understandable. This standard is crucial for effective communication among the healthcare providers, accurate treatment planning and legal compliance. Legible record prevent the misunderstandings and errors, supporting high quality patients care and maintaining the professional and regulatory standards. So, by keeping the proper record, misunderstanding or some error or communication should be given justice, supporting high quality patients care. Accuracy, the record should be accurate and complete. Medical record must be accurate and complete, documenting patients' information, treatments and outcomes precisely. This standard ensures reliable patient care, support effective treatment planning, compliances with legal and regulatory requirements. Accurate records are essential for continuity of care, legal protection and maintaining professional and ethical medical practices. So, while keeping the record also, accuracy is important. So, record should be accurate and it should be complete. Completeness. Record should include all relevant information. Medical records must be complete, including all relevant information such as patient's history, symptoms, diagnosis, treatments and outcomes. This thorough documentation supports accurate diagnosis, effective treatment planning, continuity of the care. Complete records also ensure compliance with legal and regulatory standards and which will help to enhance the transparency and accountability in the patient's management. So, completeness of the record is another important aspect of this record keeping. Confidentiality. Record should be maintained with patient confidentiality. Medical record must uphold strict confidentiality, ensuring patient's information is protected from unauthorized access. This standard safeguards the personal and sensitive data, builds the trust and complies with legal privacy requirements. Maintaining confidentiality is crucial for ethical practice. Ensuring patients feel secure in sharing their health information and fostering the respectful healthcare environment. So, you should create such kind of rapport or such kind of relationship with the patient. So, the patient should feel secure whatever confidential history is, he should able to share with the doctors. Storage. Records should be stored securely and protected from the damage. Medical record must be stored securely to protect them from unauthorized access, damage or loss. Proper storage involves using locked access control facilities or secure digital system with backup protocols. This ensures that the patient information remains intact and accessible only to authorized personnel and maintaining confidentiality, integrity and compliance with the regulatory standards. Retention. Record should be retained for a minimum of 3 years or as specified by the law. Depends upon the case and depend upon the sensitivity of the issues, how long the record keeping should be kept, which is specified by the law. As mentioned, record should be retained for a minimum 3 years. In homeopathy, medical record must be retained for at least 3 years and as legally specified. This retention period ensures that patient information is available for ongoing care, legal inquiries and regulatory compliance. Proper record retention supports continuity of the care, facilitates accurate documentation and adheres to legal and professional standards for the healthcare practice. Accessibility. Record should be easily accessible to the authorized personnel. Medical record should be easily accessible to the authorized personnel and maintaining security and confidentiality. This accessibility ensures that healthcare providers can quickly retrieve necessary information or ongoing patient's care, treatment, planning and emergency. So, there should be easy access for the record keeping. Prolonged managed access supports effective care delivery, facilitates communication among the professionals and adheres to regulatory and professional standards. Standards for medical record in homeopathy. Standardization of record should be follow a standardized format. Record should be follow a standardized format to ensure consistency and clarity. Standardization includes using the uniform templates and coding system of the patient's information, treatment, plans and outcomes. This approach enhances readability, facilitates data sharing and supports accurate documentation, ultimately improving the quality of care and compliance with regulatory of the professional standards. So, you have to jot down the standards of medical record and it should be the format should be uniform and whatever the points you are mentioned, that data template should be uniform so that it will help for the treatment planning, to give the information to the patients whenever it has been asked, and what is the outcome or prognosis of the treatment, that will be established by keeping the standard medical record in homeopathy. Authentication. Record should be authenticated by the practitioner. The medical record must be authenticated by the practitioner to verify their accuracy and credibility. Authentication is typically involved signing and dating the records. So, time, sign and date are very important aspect in authentication of any of the data, which confirms that the documented information is accurate and has been revived by the practitioner. That is the meaning of signing and dating the record, that is called as authentication. This process unfolds the integrity of the records, ensures accountability and meets the legal and regulatory standards. Standards of medical records in homeopathy. Electronic records. In homeopathy, electronic medical records should have password protected to prevent the unauthorized access, backed up regularly to safeguard against the data loss. So, to avoid the data loss, which we are taking with so much efforts, should not get lost. So, you should have some electronic regulatory password protected files. So, only the authorized body can be allowed to utilize it. Secure encryption and routine backups ensure the integrity and availability of the patient's information. These practices protect confidentiality, support continuity of the care and comply with the legal and regulatory standards for electronic record keeping. This is called as electronic record keeping, and so that backup should be there, so that data loss can be prevented. Standards for medical record in the homeopathy. By following these legal requirements and standards, homeopathic practitioners can ensure that their medical records are accurate, complete and legally compliant, protecting both themselves and their patients. Confidentiality and data protection laws. There are certain laws for the keeping the data protected. The Indian Council Professional Conduct, Etiquette and Ethics Regulation 2002 mandate the strict confidentiality of patients' information. This regulation requires that all patients' data should be kept private and secure, accessible only to authorized individuals. Upholding the confidentiality is essential for maintaining trust, respecting patients' privacy and adhering to ethical and legal standards in medical practice. Confidentiality and data protection laws. Consumer Protection Act 1986 protects patient privacy and confidentiality. The Consumer Protection Act 1986 safeguards the patient privacy and confidentiality by requiring that personal health information be protected from unauthorized access or disclosure. That is the benefit of protection of the patient's privacy. This law ensures that patient sensitive data which they have shared with you with a lot of confidence, which remains secure, promoting the trust between the patients and the healthcare providers, that is doctor and patient relationship, and enforcing the ethical standards in handling the personal medical information to prevent the misuse or exploitation or for the blackmailing purposes. That should not be happen for protecting the patient privacy and confidentiality. Information Technology Act 2000 regulates the electronic data protection. This act regulates electronic data protection by setting standards for securing digital information. It mandates measures to protect the electronic records and personal data from unauthorized access, breaches and misuse. This act ensures that electronic health records in homeopathy and other fields are securely stored, transmitted and managed, complying with privacy and security regulations. So, there are certain laws in regard to the information technology also, which regulates and confirms and manage transmitted and stored securely under the regulation of electronic data protection. Data Protection Bill 2022 proposed comprehensive data protection legislation. This aims to establish comprehensive data protection legislation in India. It outlines robust measures for safeguarding the personal data, including privacy rights, data security and accountability for data breaches. This legislation seeks to enhance transparency and control over personal information, impacting how medical and other sensitive data is managed and protected. So, this data protection bill is passed in 2022. So, this deals with the managing comprehensive data protection legislation. Health Insurance Portability and Accountability Act HIPAA adopted in India the guidelines for electronic health data protection. This is the upgradation constantly has to be happened in the professional field. Guidelines for protecting the electronic health data, it mandates secure storage, transmission and handling of the health information, ensuring the patient's privacy and data integrity. Compliance with HIPAA standards helped the safeguard and sensitive health records for unauthorized access and breaches, enhancing overall data security and confidentiality. Confidentiality of the data and protection laws has got key points. This is one. First is confidentiality. Protect the patient information from unauthorized access. Confidentiality in healthcare requires protecting the patient information from unauthorized access. This involves implementing the strict access controls, secure the storage and encryption for electronic records. This ensures the confidentiality maintains the patient trust, complies with the legal and ethical standards and safeguards the sensitive data from misuse, ensuring that only authorized personnel can view or handle the personal health information. So, that you should not leave the trust of the patients by giving the personal health information. Privacy. Respect the patient's right to control their personal information. Privacy in healthcare involves respecting patients' right and to control their personal information. It ensures that patients have authority to decide how their data is used and shared, and without patient consent, without patient's information, you should not forward or shift the data from them or send it to the other person, fostering the trust and maintaining the confidentiality. So, you have to ensure that whatever data you are sharing or even taking the opinion, you should inform this to the patients and then do the further process. Adhering to the privacy standards is crucial for ethical and legal compliance in patient's care. So, we respect the patient's right to control their personal information. Data protection. Secure electronic data from breaches and unauthorized access. Data protection involves securing the electronic data against the breaches and unauthorized access. This includes implementing strong encryption, access controls and regular security audits. Effective data protection measures safeguards sensitive information for cyber threats and ensuring the integrity and confidentiality of the electronic health records and other critical data. So, cyber threats and ensuring the integrity and keeping the confidentiality of the data protection is very important. Confidentiality data protection key points. The fourth point is informed consent. Obtain the patient consent before sharing the information. Informed consent requires obtaining applicant patient's permission before sharing their information to anyone. Even if you want to take the opinion of your colleague or any expert, you should ask and take the permission, or you to inform and take the consent of the patient before you share the data. This involves clearly explaining the purpose, scope and potential risk of the information sharing. What is your intention? What is your purpose of sharing this, and is there really any scope or reliability or need to share this information to the other, or is there any risk of sharing this data? All these things should be taken care of while informing this data to the any other person. Ensuring the patients understand and agree to how their data will be used upholds their autonomy and complies with the legal and ethical standards in the healthcare. So, you have to ensure, you have to assure the patients, and patients should understand how this data sharing will help and uphold. So, that is the, and what are the repercussions came after that. So, the compliance should be legal and should be fit in the ethical standards in the healthcare. Confidentiality of the data protection, the fifth point is access control. Restrict the access to the authorized personnel only. Access control involves restricting access to the sensitive information to authorized personnels only. This includes implementing user authentication, role based permissions, secure login protocols. Effective access control ensures that only those with the proper authentication can view or manage the confidential data, protecting against unauthorized use and maintaining the data security. So, whom to give the access and what is the purpose of access and sharing this information, or whether it is for the authorized use or not, so that data security should be maintained. Sixth point in the key point of confidentiality and data protection laws is data encryption. Protect the electronic data with encryption. Data encryption involves using cryptographic techniques to protect the electronic data by converting it into the unreadable format. Only authorized users, description keys can access this original information. This method ensures that sensitive data remains secure during the storage and transmission, and safeguarding it from the unauthorized access and potential breaches. So, this technology is useful to maintain the confidentiality of the patients with the doctor. Data backup. Regularly backup electronic data. Data backup involves regularly creating copies of electronic data to prevent the loss from system failures, cyber attacks or accidental deletions. Routine backup ensure that data can be restored to its most recent state in case of an incident, maintaining the continuity and protecting against the data loss while supporting recovery and business resilience. So, this how to keep this backup and which are the factors or which are the points where data can be missed, that is the system failures which we are experiencing in day to day life, then cyber attacks or accidental deletions by mistake if this happens, even though if we keep the data back up properly, so electronic safety can be happen. Data retention, retain the data only from the necessary periods. Data backup involves regularly creating copies of electronic data to prevent the loss from the system failure, cyber attacks or accidental deletion. So, routine backup ensure that data can be restored to its most recent state in the case of an incident, maintaining continuity and protecting against the data loss while supporting recovery and business resilience. Data sharing. Share the data only with the authorized parties and with the patient consent. You can share the data whenever it is required, authority demand or the case are in the legal jurisdiction, but with the patient consent only. These are the important factors. Data sharing involves disclosing information only to the authorized parties only and with explicit patient's consent. This ensures that sensitive data is handled responsibly, maintaining privacy and compliance with the legal and ethical standards. Sharing is limited to what is necessary for care or legal requirements, protecting patients' autonomy and confidentiality. if it is permitted to share the data to the authorities parties, you have to understand that what is the limit and what is the need or necessary of the sharing the data is requirement in the legal aspects or in the care aspects. That aspects should be pretty clear before you are sharing the data to the higher authorities. Breach notification: notify patients and authorities in case of data breaches. Breach notification requires promptly informing the patients and authorities if the data breach occurs. This includes providing details about the breach and potential impacts and steps taken to address it. Timely notification ensures transparency, allows the affected individuals to take protective actions, and fulfills legal obligations to manage and mitigate the breach's consequences. So, notify the patients and authorize the data in cases of some breaches happens. Confidentiality and data protection: by adhering to these laws and principles, homeopathic practitioners can ensure the confidentiality and security of the patient's medical records, maintaining the trust and upholding the ethical standards. Case laws of documentation issues: Poonam Verma versus Ashwin Patel 1996, a case laws on documentation issues. Supreme Court emphasized the importance of maintaining accurate and detailed medical records. What was held is, the ruling highlighted that accurate and comprehensive medical records are not just a matter of a good practice, but also serves a crucial evidence in legal proceedings concerning the medical negligence. The case underscored that doctors and medical professionals must diligently maintain detailed records to both ensure effective treatment and protect themselves from legal concepts. Case laws of documentation: second case is Dr. Suresh Gupta versus Government of NCT of Delhi 2004. Supreme Court highlighted the need of proper documentation to establish standard of care. The Supreme Court in Suresh Gupta was of the opinion that the conviction of a doctor on charges of criminal negligence, there should be deliberate wrongdoing implying a higher degree of morally blameworthy conduct. This is what the case of the Suresh Gupta and Government of NCT. Jacob Mathew versus State of Punjab case, that is the case of medical negligence. Supreme Court stressed the importance of accurate documentation in medical negligence cases. The concept of medical negligence is not a direct form to tort, it rather comes under the concept of negligence tort law. The term negligence originated from the English tort and holds an important role in the Indian legal system. It emerges from the simple tort when any person admitted to the hospital receives the wrong treatment which results in the difficulties. It might be possible that a little problem leads to a serious or life ending situations. In cases of medical negligence, it is the duty of the doctor to exercise reasonable care and caution while giving any treatment to the patient admitted to the hospital. Rather than comparing the doctor in question to the average sensible person, the standard of care is established by comparing them to peers in the medical field. This Jacob Mathew and Punjab State 2005 case, Supreme Court stressed the importance of accurate documentation in the medical negligence cases. There can be two possible causes of negligence: either the staff performed any act without taking any due care, or the doctor performed this duty carelessly while giving a required treatment or the medicine. In some cases, both the staff and the doctors might have done with the act together, which means that the doctor and the hospital will be decide based on their agreement that how much a liability they hold separately. In the case where there are blatant procedural breaches or conduct that are judged to be reckless and irrational, courts often rely on expert testimony and evidence to decide that the negligence. In giving these decisions, the precision accurate that the law tries to find can be duties tough to the accomplish. Because of this substantial objectivity involved, as a result, the apex court has described the law on medical negligence. Therefore, well established legislation framework is needed for the consumer protection in India, and that is to not just to medical field, but to the other professional as well. Fourth case is Kusum Sharma versus Batra Hospital. Delhi High Court held that implicate the medical records can lead to top presumption of the negligence. In occur consider view, the professional principles must be kept in view while deciding the cases of medical negligence. We should not be understood to have a held and doctors can be never be prosecuted for the medical negligence. As long as the doctors have performed their duties and exercise an ordinary degree of professional skill, the competence, they cannot be held guilty of the medical negligence. You have to assume the calculated risk also, and you have to give your best as per your competency, and so that negligence cases can be prevented or avoided. It is imperative that the doctor must be able to perform their professional duties with the free mind. So, such kind of cases where they are presented in the court of law, they are giving the justice in the favor of the doctors also, so that doctors must be able to perform their duties properly and they can service to the mankind. Kusum Verma versus Batra Hospital 2011, Delhi High Court held that incomplete medical records can lead to the top presumptions of the negligence. When we apply well settled principles enumerated in the preceding paragraphs in dealing with the such cases of medical negligence, the conclusion becomes irreversible that the applicants have failed to make out any case of medical negligence against the respondents. The National Commission was justified in dismissing the complaint of the appellants. No interference is called for. The appeal being devoid of any merit is dismissed. In view of peculiar facts and circumstances of this case, the parties are directed to bear their own costs. Case laws of the documentation issues. Dr. Balaram Prasad versus Kunal Saha, Supreme Court held that failure to maintain proper records can lead to the adverse inference. That was happened in the Balaram Prasad case and Kunal Saha. The laws of the documentation issues, state government of Haryana and Srimati Santara, Punjab and Haryana High Court emphasizes the importance of accurate documentation in medical records. In this case, there was a failure to sterilization operation under the sterilization scheme. The operation was performed on the person and she was also issued a certificate with the signatures of the medical officer. General Hospital Gurgaon, they have given a immunity was rejected by Mrs. Santara, as already stated above, was a poor lady who already had 7 children. She was already under the considerable burden, and the unwanted child girl born on her created additional burden on her under account of the negligence of the doctor who performed the sterilization operation upon her, and therefore, she is clearly entitled to claim full damage for the state of the government enable her to bring up the child at least till the attain the puberty. Having regard to the above facts, we find no merit in this appeal, which was dismissed, but without any order as to costs. These case of laws emphasize the importance of accurate detailed documentation, proper record keeping, informed consent, standard of skill and care, avoiding presumptions of negligence. By learning from this case of laws, homeopathic practitioner can ensure that their documentation practices meet the legal standards, reducing the risk of legal liabilities and ensuring the quality in the patient's care. Document what you talk, talk whatever you should be documented for a good communication for the doctor-patient relationships. Thank you.